abstentions? We are joined this morning by Jeffrey Nagan and Saronis today from CohnReznick, who will frame our consideration. Thank you both for being here. I'll hand it over to you.
Madam Chair, Councilwoman Alverio has joined us.
Yes, thank you. Thank you, Councilman Jefferson. Councilwoman Alverio, welcome.
Thanks, Chairwoman Comer. To summarize our reviews, we had 11 applications that were remanded back that we reviewed for the ownership and control portion. Upon reviewing the documentation associated with those, all 11, based on that documentation, passed the ownership and control section.
Terrific, thank you. So with that, may I have a motion to approve CohnReznick's recommendation to approve 11 remanded applications that meet the social equity criteria on the basis of ownership and control?
So move.
Second.
Any discussion? Hearing none, all in favor?
Aye.
Any
Aye.
opposed? Any opposed? Any abstentions? Thank you. As a result of this vote, applicants who have met the residency and income criteria will be referred to the Department of Consumer Protection to continue with the provisional licensing procedure, while those that have previously failed any other criteria will continue the ongoing appeal process at the Superior Court based on the criteria that they did not meet. I have a question for Attorney Matrivi with regard to the previous agenda item. Are we still moving forward with that?
Through you, Madam Chair. Sorry, can you please say that again?
Yes, I'm asking about the previous agenda item and if we are still moving forward with that.
Yes, Madam Chair.
Okay,
We are going forward with it.
okay. In that case, is there a motion?
Madam Chair, is this for the reconsideration of Let's Grow Hartford?
Yes.
So I'll make a motion pursuant to Connecticut General Statute Section 4-181A. I move to reconsider the council's vote on October 18th, 2022, denying social equity status on application number ACDS 00001177 to Let's Grow Hartford LLC, without admitting that the council erred in denying the license or otherwise failed to follow appropriate procedures. I believe it would be in the best interest of the council to reconsider this application. Therefore, I move that the council notify this applicant that it may resubmit an updated application only as to ownership and control no later than 10 days after the date of notification, and that the council shall hold a vote on the application only as to ownership and control in a timely manner. The council shall apply the criteria for ownership and control that has been posted on its website on September 28th, 2022.
Thank you. May I have a second?
Second.
Any discussion? Hearing none. All in favor?
Aye.
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 Any opposed? Any abstentions? Great. We now move on to our ethics training discussion. I am looking, Director Clay, is Executive Director Lewandowski here?
He is not here. He indicated he'd be joining in a minute. Oh, he's here?
I'm sorry, I can hardly hear. Oh, there we
He
go.
is here. Yeah.
Okay, great. Executive Director Peter Lewandowski is from the Office of State Ethics. Mr. Lewandowski, thank you for being here, and the floor is yours.
Thank you. Good morning, everyone. I'm glad to be here. I hope everyone can hear me. I will start our presentation. If you just bear with me, I'll share my PowerPoint with you. Okay, I see it says host disabled participant screen sharing. I don't know if I could be allowed to, whoever has the controls over this, to allow me to share the screen. That would be helpful.
I just made you co-host, so you should be able to share the screen.
Perfect. Thank you. All right. Here we go. Hopefully you can now see my PowerPoint presentation. Okay. All right, we'll start. Again, I'm glad to be here. My name is Peter Lewandowski. I'm the Executive Director of the Office of State Ethics. And I will be, okay, let's see, here we go. Giving you an overview of the Code of Ethics for Public Officials. We'll focus on principal provisions of the code, gifts, use of state position, conflicts of interests. I'll also focus on interacting with lobbyists and contracting with the state. You as counsel most likely will interface with individuals or entities that have some business before your entity, before your board or council, that is. I'll also talk about outside employment provisions, and finally, post-state employment or post-state service revolving door provisions. This is probably the most important slide of the entire presentation. So if you forget everything that I say today, this morning, I hope you can remember this one particular rule. Always get advice. I cannot emphasize this enough. It is important to get advice if you have any ethics-related questions. There are no stupid questions in ethics. They range, obviously, from simple, straightforward fact patterns to complex questions where considerable analysis and research is involved. But nonetheless, again, please remember to always ask for advice. Overwhelming majority, regardless of what folks say, and there are jaded comments out there about state employees or public officials. I want to stress that overwhelming majority of public officials and state employees do follow these rules, take compliance seriously. The very few that stumble, in most instances, have made a mistake, and mistakes can be avoided by asking for advice. Now, where do you obtain advice? One point of contact may be internal to your counsel. You may contact your either your ethics liaison or agency counsel or for advice, an attorney within your entity. Who may provide you with responses to any questions you may have relative to any internal policies. You may have an ethics policy that may be more restrictive than the Code of Ethics. So it is important to check internally. And if you have then any subsequent questions or general questions about the Code of Ethics, absolutely, we are your resource. The Office of State Ethics Attorneys are available to you. And we pride ourselves on being very responsive. When you contact us, in most instances, you will get a response fairly quickly. If you call frequently, a response will be provided to you either on the spot or by the end of the day. Obviously, as I said, some questions may be more complex, more involved, require additional analysis. So the attorney will tell you that they have to do further research. But nonetheless, please contact us if you have any questions. The most common way of obtaining advice is by way of an informal opinion. And those opinions can be issued, as I said, fairly quickly. You can call us requesting an opinion. You can write to us by email or letter. You can also do a hybrid. You can call us first and just to gauge where you stand vis-a-vis the Code of Ethics, and then follow up in writing. Keep in mind that written opinions issued by our office are subject to Freedom of Information laws. But in terms of, again, so if you want to have this an informal, anonymous conversation over the phone is obviously your way to do it. And by the way, if you want that additional insurance of have a written documentation of that conversation, of that opinion, follow up in writing. There's also plenty of information on our website, plain language guides, the way to request advice, and so on. One note here I want to stress is there is an established firewall between our legal division and our enforcement division. What that means is when the legislature established our office, or we formed the former State Ethics Commission and established our office in 2005, they specifically focused on having that firewall in place. And in order to encourage public officials and state employees to ask for advice without any concern that that communication requesting advice will then suddenly become subject to an enforcement or be grounds for an enforcement proceeding. It cannot be. So if you have conversations with our staff compliance attorneys seeking advice, you can be rest assured that that conversation, that communication, whether over the phone or in writing, will not be subject or used in an enforcement proceeding if it's determined that, let's say, you may have violated the code. Our enforcement division has to commence their case, ethics enforcement case, independently through tips or evidence they receive from formal complaints, from their preliminary investigations. So again, that firewall is real and it should encourage you to ask for advice. Now, what about situations where, let's say, you witness something and it gives you some misgivings? We normally didn't address this before, but we've been asked to explain to state employees and public officials who are subject to the code the various channels that are available to you to convey to us any questions, any concerns that you may have if you witness some potential violations of the code. Well, one way is to have an internal conversation with your agency counsel, with human resources staff within your entity, if it's an internal matter that is specific to any internal policies. You obviously always can contact our office, legal division. You can have an anonymous conversation with our staff attorneys, and they will guide you to determine whether what you've witnessed is questionable under the ethics code. They may say, no, it's not. It's maybe an issue of optics, but it's not a violation, legal violation of the code. And then you at least, you know where you stand. If, however, it's determined that there's been some questionable behavior or actions taken by someone, clearly you have always an option to provide an anonymous tip to our enforcement division, who then proceeds with an independent investigation, and they follow up with a formal complaint. Also, keep in mind that every agency, every state entity has so-called mandatory reporters. Under General Statutes Section 1-101 PP, agency heads, persons in charge of state agency procurement, contracting, or human resources are so-called mandatory reporters to the Office of State Ethics if they have a reasonable cause to believe that someone has violated the ethics code. So if information arrives on their desk that raises these questions and causes them to have a reasonable cause to believe that that the code's been violated, they are obligated to file a mandatory report with our office. One note about mandatory reporters: their reports, they're treated in the same fashion as anonymous tips. They're not considered formal complaints. What happens is our enforcement division follows through, initiates preliminary investigation, and follows with a formal complaint. The identity of mandatory reporter is not revealed in a formal complaint. Now, speaking of formal complaints, obviously everyone who is everyone, for that matter, members of the public, but also state employees and public officials may file formal complaints. Two important points about formal complaints. Formal complaints are confidential in nature. The whole process of filing a formal complaint up until probable cause is established by a judge of a superior court is confidential. And you can appreciate why confidentiality is important. Ethics complaints can have adverse impact on someone's professional reputation. their livelihood, personal reputation, and so on. So that's why we take confidentiality seriously, and the whole enforcement process remains confidential up until probable cause is established. Once probable cause is established, then obviously the matter moves to an open public hearing before the Citizens Ethics Advisory Board, our oversight board comprised of 9 members appointed by the governor and legislative leadership. Those are citizens from throughout the state, and they hear the evidence. They determine whether a violation has occurred, and they have the authority to impose penalties, require compliance in the future with the code, require filing of any outstanding statements or reports, and then finally impose civil penalties up to $10,000 per violation. Those penalties can easily multiply. Most enforcement cases carry more than 1 violation, so that number is multiplied a few times. One more note, as I said, there are 2, even though there is that strict confidentiality provision, if you do file a formal complaint against someone, please know that the respondent, only the subject of the complaint, the respondent becomes aware of the identity of the complainant. And that's why I mentioned in the prior slide, these anonymous avenues for you to provide anonymous tips and information to our office. If you're uncomfortable filing a formal complaint, if you do, only the respondent is aware of the complaint, and only the respondent can waive confidentiality. So if someone against whom the complaint is filed then can decide, you know what, I want this matter to be out there, open in the public, out there, and he or she is the only individual who can waive that confidentiality requirement. All right. Having dispensed with the kind of preliminary important points about where to obtain advice and how our enforcement process works, we'll jump into the main provisions of the code. As we go through them, you may wonder, well, what's the point of this whole exercise? Well, first of all, we know that ethics as a discipline is a very broad discipline. Many folks are subject to ethics. Your medical doctors are subject to medical ethics. Your attorneys are subject to professional ethics. Business people are subject to codes of conduct, and so on. But when we're talking about governmental ethics, the basic premise behind governmental ethics, and whether it's on the state level, municipal, or federal, is that the law is intended to prevent a public official or state employee from misusing their position or authority for personal financial gain. So essentially, in its essence, the governmental ethics codes of conduct could be called financial conflicts of interest. So there has to be some kind of a financial element involved, and you will see that as we go through these provisions. Let's start with the first major one, and that is the subject of gifts. Gifts are generally prohibited from certain groups of individuals that may interact with you in your official capacity. What's a gift? Well, a gift is anything, and it's a statutorily defined term. That definition can be found in section 1-79 of the general statutes, and it means anything of value directly or personally received unless consideration of equal or greater value is given in return. So essentially, there has to be a market transaction for something not to be considered a gift. So if you pay $100 for an item that out there in the marketplace costs $100, well, that's not a gift. But if you pay $1 for that very same item, well, it's still considered a gift. So there has to be that equal value exchange. Now, I've mentioned you should be aware of certain folks who may be interacting with your organization. Those are the folks you should be most concerned about in terms of when you receive a gift, and they are called restricted donors. There are 3 subgroups in that basket. First, the so-called registered lobbyists. And lobbyists are registered with the Office of State Ethics, the lobbyists who lobby state government, whether the legislature or any entity of the executive branch. They register with our office. There's about 1,000 or so. Again, I don't have the exact figure, but about 1,000 client lobbyists, in other words, entities, individuals, groups, whose message is being communicated to public officials. And then about 500 or so communicator lobbyists, individuals who carry the message. We have a real-time database on our website. If you were trying to determine if someone is a registered lobbyist, you can just go to our website. If they registered 5 minutes ago, their name will be there. And they range from major Fortune 500 corporations down to very small nonprofits, local nonprofits, to also some individuals who will be registered as lobbyists. Also, you have to be concerned about individuals, or be watchful for individuals and entities that are regulated by or are doing or seeking to do business with your council. So anyone who interacts with your council, wants something from your council, who is either regulated or is trying to obtain business, or some kind of a determination by your entity, is considered a restricted donor. Okay. And finally, the third subgroup are the Department of Administrative Services pre-qualified vendor list. Those are the vendors who provide services to state agencies. So let's say your council or your office orders stationery, some equipment, let's say computer equipment, what have you. Those groups, those vendors will be listed as pre-qualified contractors. There's about 400 plus of them. They're listed on the DAS website. And again, the general rule is gifts from restricted donors are prohibited unless applicable exceptions are in place. Now, before we jump to these exceptions, there are also other potential donors that you should keep in mind. There's considered non-restricted donors. The first group really should be on your radar, and that is groups, individuals, entities that are giving you something by virtue of your state position. They may not necessarily be doing business with your office, with your agency. They may not necessarily be registered lobbyists or pre-qualified under DAS, but they're nonetheless giving you something by virtue of your position. This can be easily illustrated by, let's say, attending a conference, let's say in another state. Let's say there's a regional New England conference that you are attending, and the host of the conference is inviting you to speak at that conference, and they want to furnish certain benefits to you at the conference. Now, clearly you are attending the conference in your official capacity. The host is not considered a restricted entity, but nonetheless, they're still providing something to you by virtue of your Connecticut position, state position. With respect to those folks, you may accept anything under $100 per year, plus all the gift exceptions. And I will note these, as I said, these exceptions momentarily. Finally, the last group are folks who are giving you something that has no connection to your state service. There's no limitation on that type of gift giving. We're talking about your family, your friends, your neighbors. Unless, of course, your neighbor suddenly registers as a lobbyist, then they're thrown into the restricted basket. So let's jump into the gift exceptions. I'll focus only on the common ones that you will likely encounter in your state service. The first one is token items, and those are set to the limitations, financial limitations with these exceptions. They're set in statute, so they don't change frequently. The token item, we're talking about items valued at under $10 each, up to $50 in the aggregate per year per source. So we're talking about coffee, little mugs or what have you. I understand there's inflation going on, and there are fewer and fewer items that can be squeezed into a token $10 limit. So even coffees, the more adjectives you add to your coffee, the closer you get to the $10 mark. So, but nonetheless, as I said, these are statutorily set limits. And so token items may be accepted from restricted donors. Non-restricted folks who are giving you something by virtue of state service may also utilize these exceptions. Food and beverage, let's say someone wants to take you out to lunch who's restricted. They may do so provided they're in attendance. So again, gift certificates to a restaurant are not permitted. That individual or representative of an entity has to be in attendance. They may take you out to lunch. They have up to $50 per year available that they may utilize on you. Rebates and discounts that are available to governmental employees, governmental officials, provided they're not targeting specific agency. So again, if you go to a hotel somewhere and there's a government discount available, you may accept it. Those type of rebates are permissible. Again, provided they do not target your agency alone. Ceremonial plaques, if you are recognized for your service, you may accept a ceremonial plaque valued up to $100. Gift giving between subordinates and supervisors. So clearly, as members of the council, the staff of the Office of the Council on Social Equity, they will be your subordinates. So if there's any gift giving between, let's say, council members and the staff, that gift limit has to be set up to $100 per gift. No pooling allowed to exceed that amount. So if you are contemplating of celebrating a major milestone and you're dealing with, let's say, subordinate or supervisor, in this case, as I illustrated, if you're dealing with a staff member, their subordinates, you should give a separate gift and not participate in pooling to exceed that per gift limitation. Same rule applies to major life events. However, the financial threshold is $1,000 for those events, and the major life events are limited to, excuse me, birth, adoption of a child, wedding, funeral, retirement from state service, induction into religious adulthood, bar mitzvahs, and confirmations. Excuse me, now I want to focus on the exception that deals with attending conferences. And this is very common among state officials and state employees. We attend conferences, whether local, regional, or national. And if you attend a conference, it is assumed for this exception to apply, it is assumed that you are attending in your official capacity as a member of the council. Okay, so one, that's the basic rule. Second, what type of participation do you engage in at a conference? Are you an active participant or a passive participant? Well, active participant means you are a speaker, panelist, moderator of a panel, or let's say you're being recognized by receiving some kind of an award, okay? That's considered active participation. And when you're an active participant, you may accept necessary expenses. Technically, necessary expenses are not considered a gift because those are items that you receive in consideration of your active participation. As an active participant, let's say you're speaking, you're providing expertise, you're providing knowledge, know-how to the folks who attend the conference. Okay, so in that regard, you're not, whatever you receive in that for your active participation, it's really in consideration of that active participation. It's not considered a gift. Now, on the flip side of it is if you're a passive participant, let's say you attend a conference to learn something, to acquire new skills, to acquire new knowledge, to make your job or your performance of your state job more efficient. You may, of course, accept similar items that are available to you under necessary expenses, but for your passive participation, those items are considered gifts to the state because they're given to you to improve your job skills on behalf of the state. And then what can you receive under both necessary expenses and gifts to the state? Basic conference expenses. You know, we're talking about travel, basic travel costs, lodging, meals, related conference expenses that are not lavish. Now, what do you may wonder, well, what's lavish? The lavish standard is essentially, it means you really have to answer the following question. What would the state pay to send you to a conference? Okay, that's the key question to answer. What would the state pay to send you to a conference? We know for sure that the state will not pay for first class travel. We know that the state will not pay for you to dine at some Michelin-starred restaurant or some really fancy resort. It's the basic conference expenses that normally are provided to governmental employees. Also, the state will not pay fees or honoraria for your attendance or entertainment. So if there is a golf outing or some show that is available to conference attendees, you really have to pay out of your own pocket for those items. So that's the basic standard for what's lavish or not. One note about necessary expenses and gifts to the state, there is a disclosure requirement to the Office of State Ethics. If you attend and you receive lodging or out-of-state travel costs, you have to file a brief statement with our office. It's posted online. It's a one-pager, very simple document that will ask you to identify the conference you attended, who paid for it, and what items you've received. Again, that disclosure has to be filed within 30 days of attending the event, and it's only triggered if you receive, again, it's only triggered if you receive lodging and or out-of-state travel costs. All right, moving on. Again, so kind of a recap. What happens if someone is offering you a prohibited gift that does not meet any of these exceptions? Well, you have few options here. You obviously can refuse immediately or return the gift, or pay the donor fair market value for that gift within 30 days of receipt. Okay, so you have a 30-day window to not to be subject to potential code violations. If you you realize inadvertently someone has given you an impermissible gift, you have that 30-day window so it's not attributed to you. All right, moving on, another major area of the code and is the so-called use of state position. This provision is really what I would call kind of a common thread provision and it's very broad in its application that will go in tandem with many of these other provisions we're discussing, whether it's gifts, whether it's outside employment or revolving door. And it essentially means you may not use your state position for your own financial gain or that of your immediate family members, your spouse, your children, your child's spouse, parents, or siblings, or your associated businesses. Associated business is a defined term in the statute in section 1-79. And it essentially means any business you own or in which you serve as an officer or your spouse does. Let's say your spouse is a partner in the business. Also, if you're a shareholder of a business that where your value of the stock you own exceeds 5% of the stock outstanding. And so essentially, when you are faced with an associated businesses, you really have to have kind of a hands-off approach when you cannot take any official action for that benefit. And I'll touch upon that when we talk about conflicts. Also, an important exception to associated business, your service on a nonprofit board, uncompensated service on a nonprofit board is not considered, that board is not considered an associated business for purposes of this provision. And I know many of you may serve on some nonprofits. You may be passionate about some issue. You've been selected to serve on a nonprofit board. You're not compensated for that service. You technically may take official action in your official capacity for the benefit of that nonprofit if you are unpaid board member of that nonprofit, because that nonprofit is not considered an associated business. Okay, moving on to conflicts of interest. Conflicts of interest it's one of the major key provisions in the code. Essentially, conflicts of interest you can find in any governmental ethics code, whether on a federal, state, or municipal level. Many corporate codes of conduct will address conflicts of interest. Again, it's a very important provision and very common provision in the codes of ethics. So what's a conflict? That's the question you have to answer. You're about to take official action and you want to determine, is there a conflict? Well, what's a conflict? First, you have to answer a series of questions. Will if I take official action, whatever that is, a vote on some matter, will that official action lead me to obtain financial benefit or financial benefit to my immediate family members or associated businesses? And is that financial benefit distinct from other similarly situated individuals? If the answer is yes to these questions, then you have a conflict. And then you have to determine, okay, am I dealing with a direct or potential conflict? Or do I have an appearance of a conflict? We'll unpack all these in the next couple slides. Let's start with direct conflicts. Direct conflicts are very easy to spot. Essentially, you have a reason to believe or expect that you, your spouse, dependent children, or associated businesses will obtain direct monetary gain or suffer direct monetary loss by reason of your official activity. In a way, and this is critical, in a way that is distinctly different from others in the same profession or large group. Okay, if you are, let's say you're about to award a contract or grant or what have you to some group, some entity, or an individual, and that entity may be an associated business. You know that if by voting on the matter, that entity obtains a contract or grant or some kind of a permit from your council, there will be a financial gain, okay, direct financial gain to them, because by virtue of the fact that they've obtained a certain benefit from the state. And if that's the case, if that specific associated business is treated in distinct fashion than other similarly situated businesses, let's say the contract is specific to your associated business, well, you have a direct conflict. And what do you have to do? Well, if you have a direct conflict, you have to recuse yourself. Recusal is required. Now, what about potential conflicts? Potential conflicts are somewhat nuanced. Essentially, you're taking official action that would affect financial interests of you, your spouse. And if you notice, the group of people here is slightly larger than under direct conflicts. We're also including your parents, siblings, and spouses of your children. Also, obviously, your children and associated businesses. Under potential conflicts, there's no requirement that the financial impact be direct, okay? However, you have to have a reasonable expectation. There has to be a likelihood that you will obtain financial benefit, and that benefit is distinct, again, from a substantial segment of the public. So you have to have that reasonable expectation. It has to be likely that you will obtain financial benefit by virtue of your official action, not just merely conceivable or possible. If that's the case, that's really a matter of optics. There has to be a likelihood that you will obtain financial benefit. And if that's the case, you have two options. You either recuse yourself from taking official action, and or in the case of boards, commissions, and councils, the other option under potential conflicts is to issue a statement on the record in the official proceeding of your council, stating on the record the nature of the conflict you're facing and why, despite that conflict, you may still act in the interest of the public. A copy of that written statement has to be recorded in the minutes of your council. And also a copy of that statement has to be forwarded to the Office of State Ethics. So you have two options as a member of a deliberative body, such as the Council on Social Equity, when faced with potential conflicts on what to do. One, on the one hand, you can always recuse yourself. And then on the other, you can always prepare that written statement stating what I just said, that you can still act in public's interest when you are faced with a conflict, potential conflict. All right, what about appearances of a conflict? One note about appearances that the Office of State Ethics does not have jurisdiction over appearances of a conflict. Connecticut law is really silent about appearances of a conflict. Appearances are really left to your judgment, to your discretion. It's really an optics test, or as we say, kind of, how thick is your skin to withstand, let's say, public scrutiny out there in terms of an appearance. We will, if you come to us for advice on conflicts, and let's say our staff attorneys will provide an analysis, and they'll determine that legally you are not, you're not facing direct or potential conflicts, but nonetheless, a note may be made in that opinion that there are issues of appearance. I'm bringing this to your attention because if you're a high-ranking official in state government, some concerns about appearances. Certain appearances may have an adverse impact on the body on which you serve, on the council. It may put the council in a bad light. Let's say if let's say there are optics concerns and let's say questions of appearance raised. Whether in the media or by members of the public. So just to alert you that we do sometimes raise that in an opinion if it's really clear that there are issues of an appearance of a conflict. Even though you're not legally obligated to follow or to abstain from official actions, just be cognizant of that. All right, a few words about lobbying and contracting, because as a deliberative body, there are folks who come before you, they're asking for certain action by your council, and some individuals, some entities that may appear before you may engage, well, they engage in lobbying, but they may also be required to register as lobbyists if they trigger lobbyist registration requirements, and I'll talk about them briefly, and what exemptions apply to lobbying and lobbyist registration. First of all, just to go briefly over the definition of lobbying, and as a general note, lobbying is a constitutionally protected form of speech. So again, the Office of State Ethics, the Citizens Ethics Advisory Board, does not regulate the content of lobbying. We only regulate or require folks to disclose expenditures on lobbying, so the public so there's transparency for the public to see where are their pressure points on the governmental decision-making. So definition of lobbying essentially means communicating directly or soliciting others to communicate with any official. We're focusing on executive branch here, but this also applies to legislative branch and quasi-publics, executive branch officials, for the purpose of influencing any legislative or administrative action, in this case, administrative action, your decision-making, okay? So if someone comes before you and they want something from your council, they are essentially lobbying. Now, but the question is, do they have to register as lobbyists? Now, what's a lobbyist? Everyone, obviously, under the definition of lobbying that I just provided to you, anyone can engage in lobbying. You can have your elderly, passionate neighbor who is passionate about some issue, they come before you and engage in lobbying. They don't necessarily meet the definition of a lobbyist. You may have a little, the Girl Scouts can engage in lobbying, but they don't necessarily meet the definition of a lobbyist. So lobbying is a form of communication, a form of speech. Here, someone becomes a lobbyist if, and lobbying or in furtherance of lobbying is an activity that supports lobbying activity. For example, buying advertisements, buying research or consulting services, and so on. Those type of activities are activities in furtherance of lobbying. So a person who in lobbying and in furtherance of lobbying makes or agrees to make expenditures or receives or agrees to receive compensation, reimbursement, or both, any amount of $3,000 or more in any calendar year, okay? So the $3,000 threshold triggers lobbyist registration. If someone spends more than $3,000, they may be required to to register as lobbyists if they are engaging in direct communications or soliciting others to communicate on their behalf. Now, there are exceptions, and this is important. So you, as member of the council, will know, okay, does someone who's talking to us should register as a lobbyist? Well, not necessarily. It depends. And one major exception is the so-called salesperson exception. And this exception does not include communications by someone who's a bona fide salesperson, okay? Whose day in and day out job is to pitch, to solicit business, to solicit procurement of services or equipment. We know who's a bona fide salesperson. The same folks who walk in through your door to solicit your interest in what they have to offer. Now, technically, a CEO of a major corporation could engage in salesperson type of a pitch, but their day-to-day job is not technically being a salesperson. They definitely promote the welfare of their business, but they go beyond. Their job spec is not just being a salesperson. So when we're talking about salesperson exception, we're talking exclusively individuals who engage exclusively in sales. What about other communications for purposes of communications with executive branch agencies such as your council? Communications on behalf of a person affected by a court order. So let's say there's a court order out there that requires someone or who's affected by a court order to appear before your council. That type of communication would be exempted from lobbying. Also, preparations or submissions required by or filed pursuant to statute, regulation, or your agency rule, or let's say your agency does some form of solicitation out there in the public for of certain businesses. Let's say they wish to pursue engage in certain activity, and it is your agency or your council that initiates that type of solicitation. Any responses or communication based on established procedures will be exempted. Similarly, a very common area with state agencies, responses to requests for proposals, for contracts, grants, projects, or what have you. Those type of submissions, RFP submissions, are exempted, provided, and here's the key point, provided folks who respond to an RFP follow the established procedures and do not go outside of those established procedures. So if someone contacts a board member, goes outside of the procedures, or let's say goes to the governor's office, again, outside of the council established procedures, they would be removed from that exception. Communications made incident to the performance of a contract or implementation of a permit. So let's say someone who already obtained something from your council, certain permit or certain contract, and they come back to clarify an aspect of the contract or permit that's been given to them. Clearly, that communication would be exempted. And finally, contacts strictly for informational purposes. Let's say someone contacts your council or the office simply to understand the procedures that are established for responding to agency solicitations. One note about lobbyist prohibitions. Lobbyists, if folks who engage in lobbying are already registered as lobbyists, clearly, we've already talked about this, they may not give gifts to public officials, state employees, candidates for public office, and their immediate family members. Lobbyists also, one note, very important, state agencies, including the council, also quasi-public agencies, are prohibited from retaining outside lobbyists. So your office may have a staff member who is a legislative liaison, or let's say board members may appear before the legislature if you lobby on some aspect of state law. But the council and the office would be prohibited from retaining an outside lobbying firm, and that prohibition stems from well, almost 20 years ago when there were issues with the, if you may recall, Enron Corporation back in the day. Lobbyists may not are prohibited from doing anything with the purpose of placing any public official under personal obligation. And finally, lobbyists are prohibited from engaging in contingency fee arrangements where their compensation would be paid on the outcome of some administrative action. Let's say your council, let's say someone has some business before your council and a lobbyist appears before your council. They are prohibited from having contingency fee arrangements where their compensation would be contingent upon the decision making of the council. Some comments about state contracting. One provision that every state agency should keep in mind, and this is General Statute Section 1-101 NN, which prohibits state contractors and those seeking to obtain state contract or grant from soliciting information. They're prohibited from soliciting information from a public official, state employee that is not available to other bidders for that contract with the intent to obtain a competitive advantage. In other words, bypassing the bidding process in order to position themselves favorably in a competition for that contract. That type of activity is prohibited. For example, also intentionally or recklessly charging the state agency for work not performed or goods and services not provided. Falsifying invoices or bills, intentionally violating or circumventing state competitive bidding and ethics laws. This provision is very important because if you do, if, for example, it is determined that some entity that's been trying to obtain state contract is bypassing the established bidding processes, they may be deemed a non-competitive bidder by our office. They may also be prevented from pursuing future state contracts. Also, if there's a criminal element involved in their activity, we may refer the matter to the state's attorney's office for criminal prosecution. And also, if they've obtained a financial advantage by, let's say, obtaining a contract by circumventing the bidding process, any financial benefits, any profits obtained out of that contract may be recouped by the action of the Attorney General. So I just want to bring this to your attention because if you engage, if your council has situations where, let's say, someone is violating state bidding laws, that they are subject to serious consequences. All right, two more subject matters I want to touch upon. Outside employment. Public officials and state employees may engage in outside employment, and of course, you as members of the council, you have your private endeavors in which you engage in, and there are certain rules as to what you may or may not do vis-a-vis your service on the council. Generally, the ground rules for outside employment are as follows. Your outside employment must not impair your independence of judgment as to your state duties. You may not disclose confidential information that you've learned in your state service for the benefit of your outside endeavors, your private employment. And you may not use your state position for the benefit of your outside employment and so on. And we'll talk about more specifically about these various outside employment rules. What that means, you may not accept outside employment in an area or industry over which you have regulatory authority. As you may not be paid privately to do what is essentially already required of you in your state job or state service. You may not use state resources, common sense. You may not use state time, materials, equipment, personnel to further outside employment. Use state title and advertising materials to promote your outside employment. Here, I just want to unpack this a little bit. So let's say in your private endeavors, you have a consultancy business or some other service-related business. And let's say you have your own private website. If you have promotional materials on that website where you are promoting your services to the public, you should avoid advertising the fact that you're a member of this council. However, you may note your service on the council in your CV or your resume that may be attached on the side. So you should not use your title in promotional materials, but you may note your title and your position with the council in your resume or on your CV. Also, there's no problem for you to note your current service on the council if you, let's say, have a LinkedIn web page. Unless, again, that LinkedIn page is intermingled and linked with your promotional materials. So separate those two if that's the case. You may not attempt to drum up business from contacts made in state service or exploit state contacts for benefit of your outside employment. You may not accept outside employment where state position lends credence to your private practice, which does not arise from your expertise alone. And again, that's kind of related to promoting, to bolstering your credentials by the fact that you serve on this council, if you are accepting employment or contemplating of accepting employment with someone. And finally, you may not accept outside employment that would interfere with your ability to devote requisite time and energy to your state position, to your official position with the council. You constantly have to recuse yourself. And we're talking about, frequent recusals, frequent abstentions, or absences from your service on the council. You really should consider, serving one or the other, whether you're outside employment or your council, because it's your colleagues depend on your service, the public depends on your service, and that's where if you're constantly in conflict, then absolutely that's a concern. Just one note, this is, for example, in your interactions with staff members of your office, state supervisors. So obviously, again, this applies to board members and in their interactions with staff members of your office. It is impermissible for supervisors to hire subordinates in their outside businesses and vice versa, subordinates to hire their supervisors. This is per advisory opinion from 2008-5. One note, ancillary note to outside employment every public official and state employee, generally speaking, can engage in state contracting. And let's say if you have an outside business, that outside business may pursue state contracts. And if that contract is valued at $100 or more, it must, however, undergo open and public process. In other words, your outside business may pursue state contracts. However, you have to follow the same rules and processes that Joe Public has to follow. In other words, open and public process. Agency heads are prohibited from pursuing state contracts. And finally, the last topic I want to discuss is the revolving door area. There are 4 basic rules that you should keep in mind: 2 lifetime restrictions and 2 one-year restrictions on post-state service. I'll focus first on the lifetime bans. The first one, common sense: you may not disclose, use confidential information acquired in state service for your benefit or that of another person. Confidential information is defined in General Statute Section 1-79. The other lifetime prohibition is the site switching prohibition. Here, however, I want to stress that this provision is very narrow in its application. And essentially what it means is you may never represent anyone other than the state concerning any particular matter in which you participated substantially while in state service and in which there's substantial state interest. Now, first of all, the key thing to remember, particular matter, what are we talking about? We're talking about specific contracts, specific grants to entity X or Y, specific permits. We're not talking about, when we're talking about particular matters, we're not talking about matters of general applicability, such as statutes, regulations, policies. So let's say your council promotes amendments to general statutes or regulations or institutes certain policies. So long as these are of general applicability, they're not considered particular matters for purposes of this provision. Now, if this provision is triggered, what you have to do, so let's say you leave your service on the council and down the line you obtain employment with an entity that obtained a specific contract or grant from the council. If any issues arise regarding that contract, you may not represent that private entity before against the state. In other words, you have to abstain. This is a side switching provision. You may not represent a private party in a matter that you've handled while maybe voted on while serving while in state service. Okay, so again, these are easy to spot. You will recognize if there's a matter that you've handled while serving on this council, and what you have to inform the private employer that someone else has to represent them before the state. And this is a lifetime prohibition, so please keep that in mind. Now, we have 2 one-year restrictions. The first one, the so-called cooling off provision: for 1 year after leaving state service, you may not represent anyone other than the state for compensation before your former agency concerning any matter in which the state has substantial interest. And the key thing to remember is for compensation. So technically you could represent someone within that first year, represent someone before the council on the pro bono basis. But I want to stress that it has to be truly pro bono. This cannot be delayed compensation a year or 2 years or 3 years from now. Okay, so truly pro bono representation is permissible within that first year. If, however, you engage in a representation, this is an agency-specific prohibition, so it applies only to your former service. It applies to council on social equity. It does not apply to all other agencies. You may engage in representation before other executive branch agencies immediately upon leaving state service. Now, what type of representation is prohibited? Clearly, any representation that reveals your identity to your former colleagues on the council or on the staff, whether making phone calls, sending emails, sending letters, signing documents, any documents, let's say contract applications where your signature is present, that would be in violation of this provision. You can, of course, provide within that first year of post-state service expertise and counsel to your private employer, but behind the scenes, your identity cannot be revealed in any communications within that prescribed 1 year period. You may socialize with your colleagues, provided no official business is transacted within that 1 year. And finally, the last or the second 1 year restriction, and this one is also narrow in its application. It applies. This is a prohibition on employment, and it prohibits you from pursuing employment with an entity that is a recipient of a state contract valued at $50,000 or more if, and this is critical, you were substantially involved in supervision, negotiation, award of that contract, and that contract was signed within your last year of state service. This is a dual ban on employment. What that means is not only you are prohibited from pursuing employment, but the private employer is prohibited from hiring you for 1 year following your state service if they were the recipient of that $50,000 plus contract. And that's all I have. I'll be happy to answer any questions you have. Here's our contact information. So I know this was somewhat lengthy presentation, but again, as I said at the beginning, if you forgot everything I said, I hope you can remember the third slide, and that is always seek advice. So if you have any questions, I'll be happy to answer them. And if you don't, that's fine. You know where to find us.
Thank you so much, Director Lewandowski. Councilwoman Shaw.
Thank you, Madam Chair, and thank you, Peter. It was great to see you. Always nice to get a customized walk through the ethics code. I just wanted to just confirm that there is no distinction between state employees and those who serve on a board like the Social Equity Council when it comes to the Code of Ethics. Is that a accurate way to summarize how it applies to us?
Yes, it's generally most of those provisions apply to councils of state boards. The only exclusion that we have under the code applies to advisory boards, but you are not advisory board. If you exercise regulatory authority of the state or expend state funds, and regulatory authority of the state also extends to giving permits, grants, contracts, and so on. If you exercise that type of authority of the state, you are not considered a member of an advisory board, and therefore you are subject to all these provisions of the code, with few exceptions. I noted one, for example, under conflicts, you're faced with a potential conflict. You have two options. Whether state employees don't have that option, they have to recuse themselves and don't have the option of acting in public's interest. Also, one provision that does not apply to and I did not even mention that, but there's one provision under outside employment. State employees are prohibited from engaging in outside employment with entities that are in the business of representing others before regulatory agencies. So, for example, I, as an attorney, would be prohibited under the law from pursuing employment with a law firm that is in the business of representing others before, let's say, insurance department, banking, DEEP, those regulatory agencies. That restriction does not apply to members of the boards. And so there are a few exceptions here and there, but by and large, most of it applies to equally to board members and say full-time state employees.
Thank you. Councilwoman Alverio.
Thank you. Thank you so much. This presentation was excellent. I mean, not just for service on this council, but in general. I have a question that it's kind of in the weeds a little bit, and it has to do with the conflict of interest and optics and making that decision. So hypothetically, if someone, a member of our council, is running a conference, for example, right? And the Social Equity Council purchases a vendor table. So now you're purchasing a service to inform the community. If the person on the council is the one running the conference, is that considered a conflict of interest? But you're purchasing like an information table or whatever it is.
You're purchasing information table from the vendor or
From the yeah. So for example, if a member of the council is running that conference, right?
Yeah.
But there's a marketplace and
Yeah.
there's an opportunity to have vendors there
Mhm.
talking about their products and services.
Yeah.
And the SEC purchases through their budget and marketing, whatever it is, budget purchases the table to participate in that. Is that considered a conflict of interest, or does that fall more under optics? I know this is more in the weeds, but it's just kind of like an example of.
If it's an expenditure made by the council, because let's say a member is hosting a conference, that wouldn't be an issue. It's more, you know, it's left to the auditors really on how the council expends its funds, assuming the conference is related to what you do officially as a council member. I mean, that's the basic understanding, is that the council is related to the subject matter of. I'm sorry, the conference is related to the subject matter of the what the council does. I'm trying to understand the concerns about optics. It would be a different story or a different scenario. And correct me if I'm misunderstanding. Is if you as a board member sponsored a conference and
Not related to cannabis.
Okay. Oh, all right.
It's just a general conference, you know. Let me stop being cagey about this.
Okay.
I run a conference. I run a women's conference every year. And
Okay.
if the SEC purchased a vendor table or even became a sponsor of the conference because to get information out there, would that be considered a conflict of interest?
No. Do you derive financial benefit from holding the conference?
No.
Then there is no financial issue or concern for you, or conflict of interest. And
Okay.
even optics, here's the thing. You may be passionate about some issues. You may volunteer, for example, on some issues, whether it's, for example, women's role, women's health, and so on. You do not, again, the basic
As
understanding.
long as you're not deriving a financial
Correct,
benefit.
exactly. You do not derive any financial benefit from it. It is something that you're passionate about. There's nothing wrong, so long as you do not derive financial benefit to for example, have your agency consider sponsoring a vendor table.
Okay.
But again, on how, as I said, as I noted that earlier, how agencies spend their funds, you're fine under the code of ethics. Sometimes auditors will look, well, if your budget is limited, are you spending your funds prudently? Okay. So, but that's all. No conflicts there, and even from appearances of a conflict, I don't see an issue here because there is absolutely no financial benefit to you.
Right. Okay. Thank you.
Yep.
Any other questions? All righty. Director Lewandowski, thank you again. Really appreciate you sharing this information with the council members.
Thank you. Thank you for having me.
Sure.
Take care. Bye-bye.
You too. Thank you. Bye. We now will turn to our committee reports. I recognize that some committees did not convene since our last meeting. But if committee chairs have items to report, I welcome those presentations. Hearing none, I will then turn it over to Director Clay for her report.
Hello, everyone. No pressure. The meeting is wrapping up, so I will go quickly and as consistently as I can. So I wanted to provide you with an update as of the last vote, not today's vote. This is the picture of the first round of the application monitoring. So we have completed the retail, we completed micro cultivator. We have one outstanding delivery service, one outstanding hybrid retailer, one outstanding food and beverage. We have completed the product manufacturer, product packager, transportation, and in the DIA cultivators, we are, again, today we address the remand and we will address the reconsideration of our special meeting in November. Equity joint ventures, we have 3 of them approved, and that is ongoing until the DIA cultivators, the medical producers and dispensaries, if they choose to reach their 2 EJV maximum, go on until that. Next one. So what we have in the works, we all know that we have hired a company to provide an accelerator program. We are in the final finishing stages of having that program come online. So we are expecting to have a contract out for execution by the end of this week. A presentation to the council of the program's final offering during our November special meeting, and looking to begin program enrollment sometime around the end of November for the accelerator program to begin officially in the beginning of January. The cannabis revolving loan fund is also another ad hoc committee that was created, that was chaired by member Gaddis. We are in the final stages. This is a program that we are doing jointly with the Department of Economic and Community Development, and it will provide loans to approved social equity applicants to help start and stand up their businesses. We will also be presenting this program institution at the November special meeting. We are planning and starting to reach out to those social equity applicants as we are finishing up the first round and meeting all of the, getting all the approvals for social equity applicants. So we do have planned on November 14th, a Zoom meeting, which will be a roundtable meet and greet. And we will talk with those folks who have been approved as social equity applicants, a little bit about the supply chain, the next steps to success. We will go over the accelerator program, the availability of that program. We'll talk about workforce development plan criteria, and we'll also introduce and talk a little bit about the cannabis loan program overview. We will also use that time to begin collecting information on the social equity applicants. We don't know right now what their workforce demands are, and so we'll start talking with them about that so that we can begin, when we put out our RFP for workforce training, we'll know what these folks need and what they're looking for. And as I just said, the first round of the adult use cannabis lottery is nearing completion. We have 3 lottery licenses outstanding. We are addressing the reconsideration, and many duties are ongoing.
I'm so sorry. I'm having a hard time hearing, Madam Chair, the director.
Yes,
It's just me. I turned the volume. I'm not sure it's my
Okay.
computer.
Yeah,
Sorry, ma'am.
comes in and out. I agree.
I'm sorry, is this better?
No,
No, it's on earphones, so I don't know. And I have my volume. Let's try to talk a little louder. Any better at all?
A little.
We have submitted proposed 24-25 budget that was submitted to OPM on October 3rd, and we are now in the process of kind of addressing questions that the OPM has related to the proposed budget. The DIA map was recertified, and we will be working with the policy committee to determine its use for community reinvestment and the next round of the lottery. And our goals are to provide you with a little bit of an update on some of the things that we've worked on and some of the things we've completed, and things that, again, that we are in the process of working on. So,
Eddie, is something else on?
pardon me?
I'm having a difficult time. It sounds like an echo.
Yeah, there's a lot of background noise. I'm not sure if you have earphones in, that might be it, if the mic isn't working as well as it could.
Is that better?
A little bit.
Kind of wiggle the plug-in for earphone.
Might have another program open.
Is this better?
If you speak louder, I think that will help.
Okay, is this better? Can you hear
A little
me?
bit.
Okay, I will definitely have IT check my, all of my stuff. I can hear perfectly fine, so I'm fine with that. So in the goal area, in our goals for operations, so we again developed the fiscal 23 budget. It included line items and positions that we are looking to fill, to add on to the staff. We also, I just wanted to kind of do the distinction that I discovered that we talked about a vendor list for the social equity applicants to have access to construction workers and, you know, folks that they need to start their businesses. And so we do have that list, which is at the Department of Administrative Services through the Supplier Diversity Program, is a list of small and minority businesses registered with the state of Connecticut. Or one term that I did learn is the cannabis supply chain, which I thought were those people. I am now learning that the supply chain is actually the other licensed companies that will supply each other. So when you have a product packager, the product packager is a part of the supply chain for the grow facilities. The retailer is a part of the supply chain for the grow facilities. So we'll be talking with the supply chain at our November 14th meeting. Under legislative and communications, legislative recommendations have been forwarded. We do have a press release template that we are using after each meeting and after each vote, and to provide additional information. That template is actually reviewed, or the press release itself is reviewed by the governor's office prior to its being released. Talking points for social equity council members are provided as needed. So if there is an opportunity for members to talk to the public or to be interviewed by someone from the media, we are working with those members in providing the most up-to-date information for that. Maintain legislative relations. We have been meeting with members of the legislature, but as you all know, we have an election coming up, and most folks have asked us to circle back with them after the election. So we will pick that up after in a couple of weeks. For legal and policy, so draft communications, that is ongoing. Draft communications is for our social equity applicants. So the letters of notification as to their status, those are done. They have been going out. And we will also be working on regular communications with them as they get their provisional licenses and work their way through to full licensure. Developing the list again, BAS, the contractors, available contractors, the Department of Administrative Services has a host registered Connecticut-based small businesses that will introduce the folks to the new services and programs. As far as the program is concerned, again, the accelerator program, we are finalizing the program this week, and we'll be making a presentation to the council next. and process checklists. So we have a bunch of checklists that we have been using internally. One of them that has been very helpful to us is the checklist that we use to make sure that we get all of the information out and we've dotted our I's and crossed our T's for each of the monthly and special and committee meetings of the council. We are and have been meeting with various state agencies as needed or as the times become available. So we're talking with those interagencies, especially those agencies that have responsibility in this legislation. Scheduling notifications. So we have been notifying council members of the various filings that are required. One example is required to have ethics training, so we took care of that today. And the statement of financial interest, we've been working on that, getting council members to complete that extension.
A little more volume, Jenny.
I'm at max for my volume on my computer.
Okay.
Okay. Let's see. And again, we mentioned providing support to the social equity applicants. So again, the roundtable on November 14th, we created a database where we have identified each and every approved social equity applicant. So we have them all in the database, which we are able to do merges and emails and other information to communicate with them in a timely manner. We are also going to be providing technical assistance to the social equity applicants, again, around the next steps to full licensure. Under workforce development, we will again be doing surveys of the social equity applicants, their companies, and what their demand and needs are for training and putting together workforce development training programs that they can have access to. Okay, and then we have the upcoming committee meetings. Again, the next scheduled finance committee meeting would be the 17th of November, outreach the 11th. Now we'll work with the outreach committee because the 11th is Veterans Day. So we'll work with the committee on our rescheduling that meeting for a different day that is a state holiday. Workforce committee is scheduled to meet again on November 16th, policy, November 17th, governance, the 23rd. We'll also talk with the governance committee if they'd like to reschedule, since this is the Wednesday before Thanksgiving. And the next full council meeting, as far as a special meeting, we are working on the week of November 14th. So we are still waiting for a couple of responses from council members on which date in our Judith poll works best for them and that we can secure a quorum. But then the next monthly meeting of the council will be on Tuesday, December 16th. I also wanted to just bring to your attention that we put into the invite the quarterly financial report and statements. So you should have that. I will ask Jennifer to pull that up on the screen just so you can have a look at it.
So, Ginny, just in the interest of time, I'm wondering if you put it in the invite, if council members can just review it on their own and circle back with you if they have questions.
Absolutely. That would be fine.
Okay, great. Thank you so much.
Okay.
Any questions regarding the presentation? Councilman Palka.
Well, thank you. Really quickly, I filled out the doodle poll, indicated I'm available on the 15th, but not the 14th. I think I'm the only one who's not available on the 14th. So I absolutely understand if we need to go with most members are at, but I didn't know if there's an opportunity to include an afternoon time slot. Did we decide early that we're sticking to the mornings for these? Both options were, I think, 10 a.m. to 11:30 a.m. I wondered if there would be benefit to seeing if members are available at an afternoon slot on either day. Again, if this was,
Yeah, so we can resend it and add an afternoon slot.
Okay.
Yeah, that's fine.
Thank you.
Okay.
Anything else? All righty. Councilman Jefferson.
Yes, Madam Chair, through you, just a follow up to Councilman Pelka's comments. So are we talking about the 14th or the 15th or the 14th in the afternoon?
So we will resend the doodle poll, including the times that we listed, and then include an afternoon on those dates as well. I think we said the 14th or the 15th, but there is, as Member Palka said, they're both in the morning. So we'll add an afternoon slot to both of those days.
Okay. Thank you.
Councilwoman Shaw?
Thank you, and thank you, Ms. Clay, for the report. For my own understanding, it's always, I think, helpful to kind of assess everything that you've shared with us, the discrete actions that are being taken by the office, to square that with our strategic plan. And I know that a strategic planning session was postponed. Curious to know if there has been a date set for that, and whether there's kind of like a timeline with kind of the elements of what you reported to us today.
So we are still trying to work on the strategic planning session, which we at one point called the retreat. So we're just trying to figure out how we can do that. And to meet our goals. And that again is to have some strategic planning session. And we're trying to do that outside of the public. So we're trying to figure out how that happens. It may not be able to happen, and if not, then we will go ahead and schedule it. So I will talk more with your chair and other members of state agencies, whether it be ethics or freedom of information, to finalize what we are allowed to do as a council.
All right, I would just underscore that there have been expressions of interest in making sure that we as a council remain centered on the core objective of the legislation, which is to ensure equity. And part of that broader discussion was, I think, agreement that we really needed to strategize on ways in which the community impact component of this work would be best achieved. And in my mind, that requires strategy. It requires strategy with respect to the ad hoc committee that Mr. Gaddis is chairing. It requires strategy with respect to assessment of workforce development plans. So there are a lot of moving parts. It's multidimensional. And I know for one, my contributions to this council, I think, would be sharper, more informed if we had kind of a, consensus around a plan of action.
Thank you. Any further questions, comments? Okay, hearing none. Is there anything outstanding for the good of the order? If not, yes.
Just
Councilwoman
real
Alvarez.
quickly, it would be great to get an update on the pause that has been put on the agency, the marketing agency at some point, if we can include that, whether it's at the next meeting, but it'd be great to either have a communication. The agency has not been working for almost 3 months now, so, or it's 2 months. So just get an update on that would be helpful.
We will provide that.
If nothing else, I'll entertain a motion to adjourn.
Second.
Thank you all for your patience. Have a wonderful rest of your day.
Thank you, Madam Chair.
Thank you, Madam
Madam
Chair.
Chair.
Bye-bye.